Hello guys, how are you? Today's topic is plea bargaining. As you know, I have already intimated you in the last video that the upcoming video will be on plea bargaining as per the provision of Bhartiya Nagarik Suraksha Sanmhita 2023. This topic is very relevant for your judicial examination as well as academic law, legal or LLB course. Okay? As you know that plea bargaining is a certain provision given in the BNSS 2023, even it was earlier given in CrPC also. It is such a thing which has been provided to expedite the judicial system, speed, and to provide justice to the concerned party and to reduce the burden of the court. In brief, I can say that this system, this legal provision of plea bargaining was brought into action or into force only because of two things: to expedite the judicial proceeding as well as to reduce the burden of the judicial system or the court. Okay. Now, this plea bargaining has been provided in chapter 23 of the BNSS 2023, in which section 289 to section 300, there is a provision with regard to the plea bargaining wherein various provisions and various details has been provided therein. Right? So what is plea bargaining? Plea bargaining basically a kind of settlement between the both parties. Both parties means accused and the victim, under the guidance of legal system or under the guidance or under the rule of the law provided as per the act, to dispose the case in such a manner that both parties should be satisfied. Now, what is the process of plea bargaining? Where the plea bargaining is applicable? Guys, before proceeding in this regard, I will tell you that plea bargaining is applicable to certain offenses, not in all offenses. Now, question will raise in your mind that which offenses will be there to be settled under plea bargaining. So, any offenses having the provision below 7 years, okay, below 7 years will come under this provision. Basically, there are three limitations of the plea bargaining provisions. Sometimes even in your judicial examination or academic course, question will be arised, what are the limitations of the plea bargaining? So I will discuss about the limitation first. First, plea bargaining is not applicable to the repeat offender of the same offense. First point. Second, plea bargaining or the chapter 23 wherein plea bargaining has been provided is not applicable to an offense having the provision of death punishment, life imprisonment or imprisonment exceeding 7 years of the period. Okay, so these three kinds of offenses will not be covered. Third limitation is that if offense is related to or any juvenile or a child under section 2 of the Juvenile Justice Act 2015 is covered therein, then this chapter 23 will not be applicable over there. These three things are the limitation upon the plea bargaining. And if fourth you think, then this plea bargaining should be voluntary. It should not be persuaded or it should not be under any kind of pressure or coercive action or anything else. Okay, so this is the fourth limitation. Now, come to the point, what are the processes in this regard? है ना? तो ऐसे में सबसे पहले accused is eligible person to file an application for plea bargaining under section 289 and 290, 291. So under section 290 of the BNSS, accused will file an application before the court that I want to take the benefit of plea bargaining provided in chapter 23 of the BNSS 2023. Now, the application will contain certain information or certain things. First, application will be filed within 30 days from the date of the framing of the charge against the accused. ओके जब चार्ज एक्यूज के अगेंस्ट में फ्रेम हो जाता है तो उसके 30 डेज के अंदर ही एप्लीकेशन फाइल होना चाहिए. सेकेंड पॉइंट, एप्लीकेशन शुड contain or should enclose an affidavit statement recorded under oath that the accused has never been convicted in same kind of offense. First thing. Second, the accused has filed this application voluntarily without any pressure or coercive action or from outer side pressure. Okay, these two things will be there. And even in affidavit it will be also stated or mentioned that accused is well known about the punishment after the plea bargaining. Okay, matlab he is aware of the nature of the offense and compensation or punishment of the plea bargaining, है ना, after plea bargaining. चलिए, once application has been filed, then court will take cognizance of this and will issue a notice to the concerned party. To the concerned party means what? Concerned party means the public prosecutor on behalf of victim and the accused. Correct? And third notice will also be sent to the police officer if case has been instituted on the basis of the 193. Section 193 means on the basis of a police report filed by the police officer under section 193 of the BNSS. Correct? तो चलिए इसको थोड़ा सा और डिस्क्राइब करता हूं क्लैरिटी के लिए कि कोई भी ऑफेंसेस कोर्ट में दो ही तरीके से फाइल होता है. वी नो एंड यू ऑल्सो नो, यू मस्ट बी नोइंग. पहला जो पुलिस स्टेशन के थ्रू मजिस्ट्रेट तक पहुंचता है, कोर्ट पहुंचता है, और दूसरा जो डायरेक्टली मजिस्ट्रेट के पास जाता है. जो पुलिस स्टेशन के थ्रू पहुंचता है उसमें पुलिस रिपोर्ट की जरूरत पड़ती है, और जो मजिस्ट्रेट के पास पहुंचता है उसमें पुलिस रिपोर्ट की जरूरत नहीं पड़ती. मतलब पुलिस रिपोर्ट के आधार पर वो केस इंस्टीट्यूट नहीं होता है. करेक्टली? Now, in both type of cases, you will find that there are different stakeholders in this regard. When the case is filed before the court through police or through FIR, it means three parties are involved. First, the accused, second, victim, and third is police officer making the report. Correct? When the case has been filed before the court or instituted, filing an application or complaint to the magistrate directly without going to the police station, then two stakeholder will be there, accused as well as the victim. Accordingly, the provision has been given in this regard also in the plea bargaining. We'll discuss later on, but I have just clarified it. Now, after receiving the application, one notice will be issued to the concerned party as and when and circumstances are there, in depending on the facts and circumstances, how the case has been instituted, how the case I have already discussed. So notice will be given to the concerned party fixing a date of hearing that accused has filed an application for plea bargaining. You come and discuss, okay, appear before the court. अब उस hearing में ये discussion होने के बाद if everybody is consented or given or agreed to proceed in that direction, means plea bargaining direction procedure, then court will give 60 days period, okay, to settle the matter or to prepare MSD. What is MSD? Mutually satisfactory disposition, which is given in section 291. Okay, section 291. So MSD तैयार करने के लिए इन सारे कंसर्न पार्टी को बताया जाता है कि आपको 60 दिन का टाइम दिया गया. ओके, अब यहां पे देखिएगा एप्लीकेशन फाइल होने में, हियरिंग होने का जब बुलाया जाता है एप्लीकेशन फाइल होने के बाद, ड्यूरिंग दैट पीरियड एवरीथिंग विल बी डन इन कैमरा. कोर्ट विल ट्राई टू इंश्योर और विल सेटिस्फाई इटसेल्फ वेदर द एप्लीकेशन हैज बीन फाइल्ड वॉलंटरली और नॉट. ओके, in this process, if the court satisfied itself that it was filed voluntarily, then plea bargaining proceeding will be started and 60 days will be given to the concerned party. If the court satisfied itself that it is filed voluntarily, but the accused has already been convicted in the same offense earlier, then the plea bargaining application will be rejected and proceeding will be done as usual as per the BNSS. No plea bargaining proceeding will be commenced. Okay. Next point, if the court satisfied itself that it was not filed voluntarily, it was filed involuntarily under pressure, okay, or coercive action, then this proceeding will be stopped, means application will be rejected and normal procedure will be continued as usual. Okay. Now, once 60 days has been given to the concerned party to prepare MSD महेंद्र सिंह धोनी, राइट, याद रखिएगा MSD महेंद्र सिंह धोनी, बट डज नॉट मीन दैट MS धोनी, है ना, इट मीन्स दैट म्यूचुअली सेटिस्फैक्ट्री डिस्पोजिशन। सो म्यूचुअल सेटिस्फैक्ट्री डिस्पोजिशन तैयार करने के लिए ऑल कंसर्न पार्टी को नोटिस दिया जाता है। अगेन वंस अगेन कोर्ट विल इशू नोटिस टू द पब्लिक प्रोसिक्यूटर, टू द विक्टिम, टू accused, to the advocate of the accused, as an even advocate of the accused will also be allowed to participate in that. Okay, once they agreed and create MSD, mutually satisfactory disposition, then it will be presented before the court, and the court will make a report on this, and it will be signed by the presiding officer along with the sign of the participants, concerned party, है ना, concerned party who had participated therein, correct? उसके बाद then one more hearing will be fixed, means दो चीज होगा, क्योंकि अब नाउ जजमेंट की बात आ रही है। नाउ नेक्स्ट जजमेंट विल बी गिवन बाय द कोर्ट आफ्टर मेकिंग द रिपोर्ट ऑन MSD। देन दिस जजमेंट विल कंटेन टू पार्ट्स, one compensation which is already given and which will be given to the victim, okay, and accused will be giving, and second with regard to the punishment. If here three things I will be discussing. पहला चीज, अगर ये पता चलता है कोर्ट को कि ये जो accused है ये फर्स्ट टाइम ऑफेंडर है, करेक्ट, फर्स्ट टाइम ऑफेंडर है, तो ऐसे केस में जो पनिशमेंट उस ऑफेंस के लिए प्रोवाइड किया गया था उसको उस 1/4 पनिशमेंट देगा। मतलब पनिशमेंट डिसाइड हो सकता है, करेक्ट, हो सकता है, लेकिन 1/4 देगा, अदरवाइज वो हाफ पनिशमेंट। अगर किसी और ऑफेंस में ऑफेंडर रहा है तो उसको पनिशमेंट का हाफ पनिशमेंट दिया जाएगा जो प्रोवाइडेड है उस ऑफेंस के लिए, पहला चीज। सेकेंड चीज, अगर उस इन ऑफेंस में एक चीज और क्लियर हुआ कोर्ट को कि ये जो है इसका कोई रिकॉर्ड नहीं है, हिस्ट्री नहीं है ऑफेंस करने का, कमीशन का, है ना, कोई मतलब क्रिमिनल रिकॉर्ड नहीं है, इस तरह का कुछ भी नहीं है, और उसे प्रोविजन ऑफ ऑफेंडर्स एक्ट 1958 के अंतर्गत इसे रिलीफ या रिलीज किया जा सकता है, या डांट डपट के भी समझा के इसको रिलीज किया जा सकता है, देन कोर्ट कैन रिलीज दैट ऑफेंडर। ओके, दो चीज। तीसरा पॉइंट है कि अगर इन दोनों चीज में कवर नहीं होता तो तीसरा यह है कि ऐसा ऑफेंस जो इन दोनों प्रोविजन में कवर नहीं हुआ है तो उसके लिए 1/4 ऑफ द पनिशमेंट प्रोवाइडेड फॉर द कंसर्न ऑफेंस विल बी गिवन टू द अक्यूज्ड, और अगर वो फर्स्ट टाइम ऑफेंडर है देन 1/6 ऑफ द ऑफेंस पनिशमेंट प्रोवाइडेड फॉर दैट ऑफेंस, करेक्ट। चलिए, लास्ट पॉइंट बट नॉट लीस्ट, जो कि आपके जुडिशियल एग्जामिनेशन और LLB एग्जामिनेशन के पॉइंट ऑफ व्यू से, कोर्स के पॉइंट ऑफ व्यू से इंपॉर्टेंट है कि प्ली बार्गेनिंग या सेटलमेंट होने के बाद, जजमेंट डिलीवर हो जाने के बाद वो केस खत्म हो गया। नाउ कैन द अफेक्टेड पर्सन और कंसर्न पार्टी बीइंग एग्रीड विद द जजमेंट फाइल एन अपील, करेक्ट। तो इस चीज में आपको मैं क्लियर करता हूं कि BNS has provided that there will be no further appeal in this regard. Crystal clear, no further appeal. Correct? First point. Second point, there is certain provision, provision has been given therein that further appeal can be filed only in 3 cases. What 3 cases? मतलब 3 provision. Either through SLP, the process, not in 3 cases, in 3 process. SLP under section 130, under article 136 of the Indian Constitution, or read petition under 226 before the High Court, or miscellaneous proceeding under section 220, under article 227 of the Indian Constitution. Otherwise, this is the finality. There no further appeal can be filed under this. Now, next important point, कि during this period, if the accused has undergone certain period of detention, तो उसका क्या होगा? ऐसे केस में that detention period, अगर पनिशमेंट दिया गया इस जजमेंट में प्ली बार्गेनिंग के डिस्पोजिशन के बाद, करेक्ट, तो ऐसे केस में that detention period will be set off, मतलब एडजस्ट हो जाएगा। अगर 6 महीने का प्ली बार्गेनिंग के अनुसार दिया गया और वो एक्यूज 3 महीने तक जेल में था या कन्विक्ट मतलब डिटेन किया गया था, तो वो 3 महीने माइनस करके 3 महीने ही दिया जाएगा, राइट। तो सेट ऑफ ऑफ द undergone detention. Okay guys, hope that it is very much clear to you for your upcoming examination or for your legal concept clarity. So thank you, keep watching, and do not forget to share, subscribe and like my videos. Thank you.